Good morning. I'm Alex Alben, and I'm a moderator for this distinguished panel. You know, it occurred to me that just the selection of this panel is very meaningful. They are all stars. They're all from the Bay Area. And the Super Bowl is in 2 weeks. And so we should think of this panel as the 49ers, the team that's going to win the Super Bowl this year, unless you're a Kansas City Chiefs fan. But we really are lucky this morning to have, some very distinguished scholars and are going to share their thoughts on this important topic. It's appropriate that we're here exploring a topic which is a relatively new thing for legal scholarship, and people are looking for answers about the use of algorithms in society. People are confused about the extent of artificial intelligence, machine learning, the fact that we have delegated a lot of our processes and decision making to computerized technologies that we don't necessarily understand. And yet they are widely used and widely adopted, and they impact people's lives, not only in the criminal justice system, but across the board in many different contexts. So it's very important to tackle these issues. And I don't think we have all the answers, but I think we have some of the good questions. And if that's what comes out of this panel, I think that would be a significant thing. We have Colleen Chien, who's a professor at Santa Clara University School of Law. Welcome. She is going to lead off the panel with a presentation. And then we have Rebecca Wexler from UC Berkeley. And batting third, to switch my sports analogies, will be Eric Goldman, also a professor at Santa Clara. So we're going to get into specific questions about algorithmic justice. What does this mean, and how is it impacting our world today? And Colleen, we're going to put up your slides, if we can. Perfect.
Let's see what I need to
get to the right slideshow.
Yes. I'm not normally that tall.
Excellent. Well, thank you so much for the introduction, and thanks so much for inviting me here. It's wonderful weather in Southern California, and it's just great to be here. So I am a law professor at Santa Clara, and my focus actually is in patent law. And I'm a person who does empirical work, data work, and I've only started getting involved in criminal justice 2 years ago, based on some pro bono work I did with my students. So with some trepidation and with a lot of humility that I opened today's conference talking, as well as thanks to tenure, that I talk about criminal justice to you and try to share what I've learned over this period of time. And I mentioned my background in part because I imagine that there's people in this room who have different expertises. Maybe you're an expert in algorithms, you're a data science or an engineering person, or maybe you're somebody who's deeply in the justice system. But I believe that what the dean mentioned earlier is completely true, that their set of questions are so important and so interesting now that it really behooves us all to be involved as much as we're interested in these topics and to get involved and get engaged. So I'm going to start by providing a little thumbnail sketch of the criminal justice system, just to kind of set the table and try to integrate probably different news items you've heard about, and then describe my own work to make 2 points that I think you may not hear too much more today, depending on what people talk about. And you certainly don't hear a lot when we think about algorithms in criminal justice. The first point is that despite the bad rap that algorithms get, there are some applications and situations in which algorithms can do a lot of good. And I'm going to talk about those and talk about them particularly with regard to the work that I'm doing. You also often hear that algorithms are only as good as the data goes into them, and that's absolutely true. But I think it's also really important to underscore that they're only as good as the people and the larger systems and institutions that they are part of. So I want to talk about those 2 points as I go into the presentation. So first, I want to just start with an overview of the system. And I always like, this is an image for the Bureau of Justice Statistics graph. And it shows the complexity of the system, starting from entry all the way to corrections. And you can't read what's on the slide, and that's partly the point, that the system is not a single system, but many disparate systems with data that's kept by many different actors. You have on the entry side, the police, the sheriff, the highway patrol. Then going into prosecution and pretrial, you have various actors going into adjudication, the courts, sentencing, corrections, the jail, the prison, the Department of Corrections. And so when we think about criminal justice algorithms and data, we need to be aware of the different systems that are out there and that they all contain different and important information, but it doesn't always come into one package. This is a slide I think that is important for those who are working in the data to realize that, again, even though a person may be traveling through the system, their ID isn't necessarily used consistently across these systems. So when you're working through and trying to understand, are the police using the correct information to try to determine whether this person might be a risk or not, or are we using the right information to determine recidivism risk? A lot of times we cannot do it well in the data. And I think this presents a very interesting set of challenges for engineers to get involved and apply the data science compensation techniques that are used all the time, whether it's statistical matching, other things, to try to make the data be more comparable and be able to talk to each other. But there's a lot of challenges, I think, when you're thinking about an individual case. Each person is entitled to their own individualized treatment and justice and the facts that are specific to them. When you're talking about mass incarceration, mass criminalization, you may need statistical approaches, and those are going to be needed to compensate for the problems in the data. So at each point in this sequence, there are decisions that are being made. So when we think about algorithms, we're thinking about the automation of decisions through computational methods. And it's important to remember that, again, the state is making decisions all along this sequence to balance public safety and personal liberty, also budgetary constraints potentially with respect to prisons, things like that. So when we're thinking about what are the decisions that are motivating the use of risk assessment, you have to think about what are the decisions that are on a day-to-day being faced by different departments in the state. Where and how should I deploy my policing resources? If you're investigating a case, what lead should I follow? Where is the killer in a particular case? But on the other side, can I rule this suspect out? Can I use facial recognition to say this person should not be included in the list of suspects because they can be exonerated based on facial recognition? Later on in the system, using risk assessment to determine should this person be let out on bail? What sentence should I give to this person? The Loomis case made that question very salient in terms of thinking about how do I determine what the sentence should be for a person once convicted. And importantly, when a parole board is trying to decide what is going on and whether or not the person should deserve parole, they're trying to look at their risk and think about what's happened in the interim since they've been in jail. Do they deserve parole based on that? So on the front end, again, thinking about facial recognition and the different bans that have gone on in different cities, the reason that these technologies are compelling is because they're trying to inform very hard decisions that have to be made. But because this is criminal justice data and we have a tradition of access to our courts as well as to public information and for public safety reasons, a lot of this information is accessible to the public and it's being used to make a bunch of private decisions. Should I rent my apartment to this person? Should I let this person into public housing? Should I hire them? Closer to home, should I let this person into college? Or should I allow this person to be bar qualified to practice law? Probably many of you have had to fill out your moral character application for your student, and you may or may not have had to pause when it said, are you aware of this person ever having an arrest record? Should this person be allowed to vote? And in many situations, the law has already been set to be to say that there needs to be a sequence that is there, and the number of collateral consequences that burden those with criminal records attest to that. But there are also situations where there's going to be a judgment call and the information has proven to be useful. So you have a deep set of private decisions that are being made. And so, you have, I guess, the system, which again is many systems, where you have decision makers and users of the data, and then you have different sources of oversight and regulation. So you'll see in the cases reference to both the First Amendment and reference, and I think Eric Goldman will talk more about that later on, information that is out there and should be accessible, but also thinking about due process and the information that's being used. You have the Civil Rights Act, you have state law, civil society, all providing oversight. The thing about this data is that it's not necessarily very very good data. It's not necessarily very precise, right? Because you're getting people's criminal histories. Often the information is incomplete, and often it also reflects policing and prosecution practices as much as it does culpability. So a person who's charged, and I've had students who've been in these, and mentees who've been in this situation where they've been charged but then found innocent, but they're still judged by the fact that they were charged in the first place. A person who's also been taken a plea still looks like they've been convicted, whether or not they were found guilty. And so the information is not necessarily the best information that's out there. So one thing I think that's important to keep in mind today is the sort of burden that we bear in working in this field to think about the civil rights community and their concerns with respect to using algorithmic tools. And so I bring up this shared statement of civil rights concerns that was signed by over 100 civil society groups, where they set forth principles for risk assessment in a particular context, but I think are more generally used. And if you followed the First Step Act and other legislative moves, I think this has been a very influential set of principles. One principle is that this risk assessment algorithm should be designed and implemented in a way that reduces and ultimately eliminates unwanted racial disparities. I think you have to talk about race when you're working in criminal justice and think about what are going to be the consequences of the act. Another burden, though, that the use of these instruments places is that we need to have civil society involve a lot of data science people and independent advisors who can evaluate what's actually happening. So here there is the principle that risk assessment tools should be developed with the community, revalidated regularly, and be done on an iterative basis, right? When we think about lawmaking, we set the law, the courts will refine it as the law gets adopted. But in code and in thinking algorithms, we are often thinking about an iterative process that gets better with data. And I think thinking about how those two sets of code, legal code and technical code, can actually inform each other and how they improve is something that is another task I think that's important to take on. So I'm going to delve now in I'll just do it pretty quickly, some of my research into what I would say sort of algorithms for good, and thinking about algorithms and how they can really automate some of the sticky parts of the system which are preventing people from getting the relief that they deserve. So this paper is called The Second Chance Gap, and it's about this difference between eligibility and delivery of second chances. There are more and more moves as we sort of make this transition in our criminal justice system to redemption, to rehabilitation, and think about how we can strike a better balance. There is now a lot of different states, all the states, on the federal level, there are opportunities to lower your sentence, get back your vote more easily, or clear your record. The problem is that in my research, I found that a lot of these times there actually is a big gap between what is promised and what is actually delivered. And the way that I got involved in this is by doing pro bono work on the Clemency Initiative. I was really excited. I worked under Obama in innovation. It didn't work on the criminal side, but he was the first president to visit a federal prison and decided after that time to accelerate and streamline the pardons process. And so, I was very excited. I worked with my students, and we filled out these forms, and we went ahead and got all the different affidavits of these people being, fitting all the criteria, perfect candidates, didn't have any violence on their record, had been really model prisoners. And we waited for these people to then get their clemency, and I was going to announce it on, to tell everybody about it, and we're going to talk about it before that. And what I found out is that the application was never reviewed because it was one of the 8,000 or so second chances that never got reviewed or became mischances. So you had about 8,000 unreviewed petition and an uptake of, according to the Sentencing Commission, about 3 to 6% of prisoners who are eligible for commutation actually receiving it. And there's a lot of different reasons why that is. I'm not going to go into that. But as I went back to just doing my regular work, I was still haunted by this question of how many second chances have become mischances. So if you're thinking about, again, the First Step Act, which was passed last year and has resulted in people being able to leave prison, again, for people that are inside, every minute, hour, and day counts. So, and sort of once I started being aware of these issues, I saw that there were many gaps that were out there. So again, miscalculations of time, people who were eligible for a remedy, but then, while waiting to get it in line, had died. So this problem seemed to be more pervasive than just the context that I had seen it in. So, okay, so I'm going to just kind of go through this really quickly and talk about how records clearance expungement algorithms can be used to clear this gap. So there's very low uptake from what we know of these remedies, but in most states you can clear your record if you have a petition. So the idea here is really to measure this gap and then to work with states to actually pass expungement laws to automate that. So this analysis took a sample of about 60,000 gig worker criminal records and then applied the rules and found that many of them could clear their records. So now I'm working with states. California passed a kind of partial clean slate, and then following Utah and Pennsylvania. Now Washington's about to announce theirs, and so you have this ability, I think, with the algorithms to automate the process, which is on paper but can't be necessarily realized. So I'll stop here and can talk more about it later.
Thanks. Colleen, you raised a lot of interesting questions, and I think one of the things that you bring out is that technology is neutral, right? It's not evil. It's not necessarily good. There are uses of technology that can really benefit people and correct injustice.
Yeah.
And you've written about that. You had a wonderful piece in the LA Times in this past August, right?
Thanks. Yeah, I was just drawing upon this. Again, it's an area where I think we just have to remember that there are positive uses of algorithms, and so I want to highlight that.
Great. Rebecca Wexler is next, and your scholarship is focused a lot right now on the maybe disparities in access to data from different people, different segments of the criminal justice system, and let's delve into that. Welcome.
Thank you. Thanks for having me. So Colleen talked in part about the risks of collateral consequences from non-governmental entities having excessive access to data. And I'm going to talk about risks of non-governmental entities not having enough access to data, specifically criminal defendants. Algorithms run on data, so who gets access to the data matters, but there's a disturbing trend in data privacy laws that's tipping the scale in criminal investigations against the accused. These are well-meaning laws. They're intended to protect consumer privacy, but they have an unintentional side effect of giving law enforcement more or better access to sensitive information than they give to criminal defense investigators. That threatens principles of parity and reciprocity, as well as accuracy in criminal justice outcomes. So let me give you two examples. First, a man is jailed, true story, for sending harassing messages and voicemails in violation of a family court protective order. After the complaining witness shows the prosecutor screenshots of the messages and recordings of some of the voicemails, defense counsel is able to establish the man's innocence by subpoenaing Spoof Card, a telecommunications service provider that allows you to send messages and phone calls pretending they're originating from somebody else's phone number. And those records show that the complaining witness sent the messages to herself. Defense counsel shares the records with the prosecutor, and the man is released from jail. The charges are dropped. That case shows why defense investigations matter. So when I talk about defense investigations, I'm not talking just big picture here about the defendant's entitlement to disclosures from the government. I'm talking about criminal defendants' independent investigative power to subpoena third parties. Due process requires prosecutors to disclose material exculpatory information in their constructive possession, but it gives no obligation on government entities to actively investigate on behalf of the defense. In our U.S. adversarial system, the duty to investigate on behalf of the accused belongs to defense counsel alone. So what would happen if the law had made Spoof Card's records selectively unavailable to criminal defendants? Here's my second example. This will show that that is precisely the situation that multiple data privacy laws are creating in the US today, both historical laws and the new wave of data privacy protections. Also a true story, this summer there was a trial of two young indigent criminal defendants who were facing charges in a drive-by shooting. The government's case relied heavily on social media evidence in order to establish a gang theory of the homicide. the defendants tried to submit a trial subpoena. If any of you followed this before, you probably saw the pretrial proceedings. But defendants went to trial. They tried to subpoena Facebook and Twitter for the contents of social media messages sent by one of the prosecutor's chief witnesses. And Facebook and Twitter said they couldn't comply because a federal data privacy law from 1986 has an asymmetry in what it allows on the face of the statute technology companies to do with the contents of communications that they store. Now, the trial judge said the defendants' Sixth Amendment and due process rights under the U.S. Constitution entitled them to this subpoena. But Facebook and Twitter still didn't comply. Instead, they moved for a stay to the California Appeals Court and the California State Supreme Court, and they were denied at both levels. Again, continued to not hand over that evidence and were ultimately held in contempt by the trial judge, who imposed what he felt was the maximum available penalty under California law, a fine. The same month that the FTC fined them $1 billion, he fined them $1,000. Facebook and Twitter did not hand over the evidence. These defendants went to trial without potentially crucial evidence to cross-examine a chief prosecution witness. One of them was acquitted, so that means that a legally innocent person had to face trial without potentially crucial evidence. That case, to me, shows how aggressively technology companies are going to interpret statutory text and why it matters that we get this right in the next wave of data privacy laws. The legislative history of the Stored Communications Act suggests that it was a pure accident of the legislative process that this asymmetry was written into the law. Lawmakers are trying to protect privacy. Law enforcement has lobbying power to ask for exceptions to those privacy laws. Nobody or few lobby on behalf of criminal defendants. Right now, we risk writing these asymmetries in at state levels, on the state privacy laws, at federal levels, and in bilateral treaty negotiations that are happening under the Cloud Act for cross-border data access. Take home point. If we want algorithms for justice that don't amplify structural inequalities in criminal investigations, or elsewhere in the criminal legal system, we need some safeguards to protect against both developers and lawmakers' potential oversight of criminal defendants' interests.
Great. I want to follow up with your point about the asymmetry that is created by these new state laws. So we have a new privacy law in the state of California as of this January 1st. It does give consumers the right to request specific kinds of data, access to data, deletion of data from a company that holds their data. How does it work, Rebecca, in terms of the asymmetry with like criminal justice?
Yeah, so in the CCPA, I think there is an asymmetry. I think there are different types of asymmetries. One type of asymmetry are laws like the Stored Communications Act that have a flat-out access asymmetry. You may not access, and you may. Other laws have asymmetries in their notice requirements. And so my reading of the CCPA is that it can be read, and again, technology companies are likely to aggressively interpret the statutory text, to impose a mandatory notification requirement when defense accesses data, but allow circumvention of the notice requirement when law enforcement accesses data. At some point, notice asymmetries and access asymmetries merge, because just like law enforcement sometimes has needs to access information confidentially, potentially because putting someone on notice could risk threats to someone's life or safety or security, harassment or intimidation of witnesses, destruction of evidence, so too defense investigators investigate many of these same people and encounter some of the similar problems.
Got it. Interesting.
Oh, can I add one more thing?
Of course.
For law enforcement folks in the room, I just want to flag this is not a pro-defense, pro-law enforcement fight here. This is neutral, and the DA for San Diego actually just filed a brief, an amicus brief, or maybe it's actually the brief, in the California State Supreme Court case pending right now on this issue called Touchstone, arguing that the Stored Communications Act doesn't apply to Facebook or Twitter, in part to try to evade this asymmetry.
Thank you.
Can I ask you a question for
Of course.
Rebecca? And also, Eric can probably address it as well. What do you think is the motivation of the social media companies in being so aggressive in reading it this way? Do you think it's So this is the law, and so we want to follow the law as written. We're not going to sort of think about equities more generally? Or do you think it's more of a practical consideration that if we open the floodgates, we could be subject to all these requests? Or is it more we want to protect the privacy of our users, and we want to have this reputation of being very zealously protecting their information? I'm just curious about what you think the motivation for the aggressive stance you described is. Maybe Eric will talk later, but
All of the above. All of the above. I personally think that if you want to be a law-abiding company, you should comply with an order under the U.S. Constitution after being denied a stay of that order by the state Supreme Court. And so I think that was excessive. But one of the reasons is that technology companies believe in their reading of the statute, and by the way, their reading of the statute is the reading of the statute that every appellate court, federal appellate court, and state Supreme Court has construed. I'm developing some alternatives to that reading, but right now they are concerned that if they hand over evidence, even in compliance with a court order, they might be subject to civil liability. So that's another reason.
Eric?
If I may. In fact, internet companies have been sued for handing over data in response to subpoenas. So they do have a non-zero concern about that civil liability concern. And even if it's a mix of all these different considerations, I would not ignore the privacy considerations here, that there really are conflicting privacy interests that can be overridden by the disclosure of information in response to a subpoena. So whether that's their true motivation or not, we shouldn't look past that and ignore that as a possible reason why they're concerned.
Yeah, absolutely. The privacy interests are legitimate. I agree completely. To put it in a little bit of context, what this particular law does is immunize technology companies from subpoena power. It doesn't immunize the information from subpoena power. So the privacy interest is a little bit mitigated there.
Are there also just resource questions when it comes to whether public defenders and others even can get access to data in their investigations?
Definitely.
Yeah. Okay. Our third panelist, Eric Goldman, is also from Santa Clara and is a more general internet law person. He runs the Privacy Certificate program there and is involved in their High-Tech Law Institute. Maybe can give us some pointers as to what we should be doing down here with our new institute. And I asked Eric to really summarize and bring together some of the themes that we've talked about.
Yeah, thank you. It's such an honor to be here today, and especially to be flanked by my two co-panelists, both of who are doing really groundbreaking work in the field. They're not only helping us understand the problem, but actually working on the matter. So it's just a treat for me because I'm not in that category, so I'm here in a different role. It's a bonus treat for me. Colleen and I literally sit next door to each other at campus. I believe this is the first time we've sat next to each other on a panel, so we're marking a milestone here that is a great honor for me. But I'm an old school internet law guy, and so my role here on this panel I think is a little bit different because my first question is, what do I have to say about the topic of creating algorithms for justice? I'm thinking about the issues in the way that we framed them starting in the 1990s, and the issues that we framed then were framed quite differently than the way the issues are framing now. What I think has really happened in the last X years, we could pick 5, 10, maybe longer, but I think that's a good number to anchor us, is the development of a field called algorithm law that has branched off or has actually just evolved independently of internet law. And so there's these conversations taking place that only have a partial cross-linkage across each other. And so I'm here, I'm going to take the role as the provocateur to talk about how I think about things in internet law and why I'm a little bit confused about some of the framing of the conversation, how then we can frame it in a way that might lend even better insights. So let me just talk a little about some of the questions I had about what we're doing here, and then that'll help pull together, I think, some of the work that Colleen and Rebecca are doing. The first question I always have is, whenever I see a title called algorithm, I say, what are we really talking about here? There's at least 3 different terms that are often used interchangeably, and they really don't mean the same thing. There can be the field called algorithm, which I think, Colleen, you described as the I'm sorry, I actually wrote it down here, the making decisions through computation. There's a field called machine learning, which is trying to get more data to help the machines make more informed decisions. And then there's truly what we would call artificial intelligence, AI, which is machines are thinking for themselves. And we often see the conversation split between all three of these. In fact, Colleen talked a little bit about how she could use algorithms for good. I think, Rebecca, you were talking more about data sourcing for algorithms. I don't actually think they hit either of the three categories here that I'm defining. And for me, that's always really difficult because those are going to have each three different dynamics in the conversation. What does an algorithm do? What does machine learning do? And the data sources for machine learning. And then AI, I don't think we really have any good examples in the field of AI, and so it's a lot more speculative. Like there's this thing out there called AI that's going to do something, but we're not quite sure what that is yet. And so, so for me, I don't think we actually have yet defined for this panel what we mean by algorithms for justice, and I do hope that we'll get there at some point. But that's really one of the struggles I have as an internet law guy. What are we talking about? Which of these three things are we talking about? Or are we just talking past each other? You're talking about algorithms, I'm talking about AI, and we're just talking about different things. The next question I have when we talk about creating algorithms for justice is who is creating those algorithms? Because it might make a big difference. Are we talking about the public sector or private sector? Government actors are going to be regulated by the Constitution, we hope, and they're going to therefore be obligated to do certain things and prevented from doing other things. Private sector won't be restricted by the Constitution, so there's a whole bunch of wider range of things that they can do. And then there's the times when the private sector is acting as a proxy for or as a surrogate of the government, which are really the ones that bother me the most, where really law enforcement is able to get around constitutional limits by just saying, I'm going to go hire a vendor to do this, and then all of a sudden we get into this constitution-free zone. But who is creating and deploying these algorithms makes a big difference. And what I find often is that we conflate all three of those categories into a single discussion, and really they might benefit from pulling them back out and identifying, well, if this is private sector, what gaps are here and how are we going to fix them? Talking about the government, what is it that the Constitution regulates, and are we just not believing that the Constitution is properly being enforced or respected? The third question I have when I talk about algorithms for justice is compared to what? If we aren't using algorithm, what are we using? And is that better or worse? So this compared to what question often gets lost in the anti-algorithms discussions. There's a lot of people who say, but algorithms are bad. Okay, but compared to what? What is the baseline that we're comparing it to? And as we know, any adjudication system, any decision-making system is going to have type 1 and type 2 errors. Those are part of the game. You don't get to avoid those. The question is, are the type 1 and type 2 errors that are created by algorithms or machine learning or AI, if you're talking about that, better, worse, or just different than the type 1 or type 2 errors that are created by other forms of decision making? So as we know, humans are biased. We know that humans make errors. And they are the baseline. If we are talking about machines versus humans, they form the baseline. Our goal is to take the best part of algorithms, machine learning, or AI and iterate and improve on what the humans can do, but knowing that they're going to create their own forms of type 1 or type 2 errors, and we're not going to get rid of those. So one of the things I find frustrating is when I see people complain about how there's type 1 or type 2 errors with algorithms, like evidence that that's a problem with the algorithms. Well, fair enough, that might be something we should work on. That's something that we probably could endeavor to fix. But it's not damning of the technology. It just means that we've created different type 1 and type 2 errors. And in particular, there's a lot of concern about the data that feeds the algorithm. And Colleen talked well about that. And of course, Rebecca talked about it in a different way. And the temptation is, well, if it's bad data, let's keep it from the decision maker, whether it's the machines or the humans. And that's fine, and I respect that. But the question then is, so what are they going to do instead? Without the data, what kinds of proxies or heuristics are they going to rely upon? Some of you may recall Leora Straffa-Levitz's article where he talked about the cross-substitution of data in making decisions for things like housing, We said, okay, so if you take away all the evidence about criminal records, then landlords just rely on race as a proxy. Okay, well, we've solved a problem, but we've created another one, or we've reiterated one that's been around forever. So are we better off? What we want is the good and not the bad, but we have to recognize that by suppressing data from algorithms, by suppressing the information, we're not eliminating the bad data problem. We might just be transferring it to some other source. And the last thing I'll mention in framing the question is what Colleen talked about, and it's something that I think both of us are passionate about, that the algorithms can be used for good. Now, Colleen's literally trying to deploy algorithms for good. But in all circumstances, every single place that there's adjudication processes, decision-making taking place, there's the potential for algorithms to actually help make better decisions. And so for me, my question is, how can we preserve the freedom to do that without the psychological baggage of algorithms being the things that are going to try and kill us like Hal did in the movie? How can we preserve the freedom in order to do that? What can we do? Alex said that technologies are neutral, and that I'm going to vehemently disagree with. Technologies are never neutral. But what I think he was trying to say, if I understand right, is that
thank you.
is that technology isn't inherently bad. It's not inherently good. It is technology, and we can work together to try and make it achieve the best outcomes, and ideally make it better than whatever it's being compared to.
That's a much better formulation of what I was trying to say. Thank you. Thank you. And I'm going to use it in the future. Thank you. I really do appreciate, Eric, your framing these issues. So one of the questions you raised, who's writing the algorithms? How do we even approach that question? Right now, basically, the data shows that, 75% of data scientists are male, and that it's a very... It's a system that is perpetuating a certain kind of culture and a certain kind of person who's drawn into that field. So do we start with saying who is writing these algorithms, and how do we create the diversity of authorship of algorithms? How do we start really addressing this issue?
The first question, of course, is compared to what? Right, again, so if 75% of the decision makers who are the black box humans who are going to be making the decision, we have that problem in our society. It's not the algorithm writers are the problem, it's a societal-wide problem.
Right.
And one of the things that I feel like the algorithmic law scholarly field has done is really helped elevate that issue and help us realize that we are codifying, we're perpetuating some of the systemic biases that in some ways we might have been willing to overlook just as a human capital problem. But now we say, actually, when we have these people instantiating their own views, now we're like giving too much power to a too limited a group of people. And so I think there's actually been some good awareness raising on that. The bottom line is we have a pipeline problem, and we all know that. The pipeline is we don't have enough diversity in the data science studies to lead to the data scientists, to lead to the better algorithms, and so it's a society-wide problem, and it's not going to be fixed anytime soon.
Yeah, let me just weigh in on that briefly. I do agree that there are a lot of biases that we have to contend with, both in terms of who's making the decisions, but also, historically the data itself has a lot of biases embedded into it. I think there are movements to say that, again, in the same way that, a patent lawyer or internet law person can get into algorithms, you don't actually have to have a particular background to be a data scientist. As you have the computational, I would say, upskilling of all different undergrads, there are now new programs that say if you're a creative writing major, if you're an English major, if you're poli-sci, you can also still get into data science. So I think there is a movement to try to reduce the barriers to entry rather than saying, we need to force everybody in one type of mold. And I think that's a very generative development. But I do want to take on your question earlier around what the difference is between the different types of algorithms versus AI versus machine learning. I think it's an important point, and for those who are trying to figure out what are the common themes, I think it is important to remember that there are certain challenges and I think particular threads that weave through the different, even if there are different, the systems are different, that make for different policy questions. So one is, basically I think in all these formulations, you're talking about information or data and machines being used to make decisions in an improved context, right? Whether it's a prediction from machine learning or it's AI in terms of thinking about, predicting or using vision. Most of AI really is, right now, 9% of it is machine learning. AI is just a blanket term. But even risk assessment, it's the same basic idea. You're using historical data to make inferences to make a prediction. So it's a very basic formulation that regardless if you're using a formula, a risk assessment tool, you're using machine learning, you're making a prediction based on information from before and some sort of logic. But what I think is different about the computer or computational approaches than a human is that there are a couple things about them. One is the scalability of that local decision that's being made. It's not something that is just within somebody's brain, but it can be propagated across a system. So if you have a risk assessment tool like that was created by Compass or some of these other systems, they're now not just limited to that one judge who might have a racist idea. It's now being used across the judicial system, right? So that tool is being used and it's scaling. So in the same way that software can scale, you have potentially a much bigger footprint. There's also the inscrutability of the information, and this has to do with, and getting to some of Rebecca's work, the trade secret problems, but also just the competence of the public to understand how that process is what's happening in that. And again, that I think behooves us to really try to make and democratize data science education so that there's more confidence in the public to be able to ask questions like, how does that decision reached, and to not accept trade secrets will prevent us from telling you, but to think about ways of using sealing and other kinds of right to an explanation, different kinds of framework. I don't want to use sort of invoking the GDPR, but there is that inscrutability problem and a level of confidence that is not there. So I think that's a unique problem. And then I think there's just this thing that is a veneer of objectivity, and what we think about, right now, if I put out my phone and I say, well, I want to, I've gone to the airport hundreds of times, from my house, but I'm still going to trust what my phone says because I think that it's more knowledgeable than I am. That's a well understood phenomena in engineering of automation bias. We tend to believe, because we think that this type of information is objective, that it has more power because it's based on more information, and that I think is also dangerous, that we endow this information and these predictions with more power than we should, especially if you knew what went on behind the scenes in terms of how the information was provided. So those would, I would say, some arguments would be different.
Sorry, I know Rebecca's chiming in here.
Well, just before we get too far along in the conversation, right. Thank you. And all of this is so compelling. You raised the point about bias in development. So I just want to flag that one of the reasons I'm worried about criminal defendants having asymmetrical denials of access to data is that, of course, the data is used both to develop the algorithms and also needed to deploy the algorithms. And so I think we have Andrew Ferguson here. He may be talking about this a little bit more later, but some concrete examples about how introduction of algorithms into criminal investigations is going to exacerbate this asymmetry from access to data would be, for instance, law enforcement can use image recognition to try to sift through vast quantities of social media data that they get because they have access under the Stored Communications Act. Because defendants don't get access, they can't use those algorithms. So too, defendants don't get access to police disciplinary or personnel files, and so defendants can't develop risk assessment instruments that are aimed at flagging police misconduct. Third, familial searching algorithms. Law enforcement is now using these algorithms to be able to analyze DNA in private sector databases. Criminal defendants, if privacy laws block access to that, won't be able to benefit from those algorithms. So in addition to being able to deploy the algorithms to serve your interests, we also, in terms of the bias of who gets to build these things, have a systemic market asymmetry where law enforcement has the power to pay to have tools developed that serve their interests, and criminal defendants generally don't.
I mean, it seems to me that there's a big gap in public education now about what these terms mean, and I'm glad that, Eric, you took some time to, parse out what are the differences in these technologies. Right now, there's a lot of fear associated with certain technologies, such as facial recognition. And the approach of some localities has been ban the technology. We're not ready for prime time, ban it. And I want to get your thoughts on that, of each of you, in terms of, is banning going to really solve the problem, or are there other tools that we should, be shining the light on how these technologies are working? Do you want to start, Rebecca?
Well, I think I'm trying to say technology can be good in some circumstances, and advocating for more people to be able to use it and benefit from it.
Right. But San Francisco has now said that in certain contexts, they're, facial recognition is banned. What's the result of that? What's the impact?
I mean, so actually, I think if I remember correctly from reading it, I think it basically says there needs to be the oversight board that's going to look at the deployment of the technology. And I think that's an appropriate response. I think, in part, it gets to some of the issues Eric and I were talking about with respect to what's different about these systems. Well, there's an adjustment, and there is a challenge with being able to exercise due process, really understand what they're doing and how they're operating. So I think that saying, let's put the brakes on this, let's wait and let's kind of take information and get that is a valuable approach. What I think would be, to me, the most, would strike the best balance would be to say, let's do pilots where we're collecting information, we're actually working with people in the community to understand what their interests and concerns are. And another sort of branch of what I work on is I try to advocate for using more experimentation to develop policy and to iterate and to understand what's happening. So I think getting the information about how it can be used for good potentially and what are the concerns is more valuable than putting an absolute ban on it. So I think that is probably what the balance that I would strike.
Yeah, I mean, the standard mantra from internet law, the way we approach it is you never ban technology, you always ban bad uses. That technology is inherently, quote, as you would say, neutral. That it's how it's used that's a problem. And this is a good example where I think we might very well want to make a distinction between private sector and public sector. That, in fact, the public sector doing certain types of activity might be more problematic than the private sector. And so we would want to subject to greater scrutiny. And if we couldn't be confident in the outcomes, go to the step, we would ban it in the public sector. The problem is the feedback loop with the private sector, that if the law enforcement or government can get around it by simply going to vendors who are able to use the technology without restriction, then we haven't really solved any problems. We just relocated it into a more obscure place. And I think that's much of what you've been working on for so long, is how much of the technology of the criminal justice system is moved into private sector hands, where the rules are different in ways that are incredibly adverse. I don't know if we can say a few words about that here, because it seems cogent.
Yeah, well, you brought this up in our prior discussions about this divide between the non-governmental and private sector and the government entities, and I thought it was so thought-provoking. So thank you for raising it. But I do think defense investigations are in this weird liminal space, because defendants are there exercising compulsory process because of a grant of government power, and they're there at all because of government power, and yet they're non-governmental entities.
Yeah, I mean, and as you've talked about, and so brilliantly, once we move the issue to the private sector, we have trade secrets that overlay on top of the issue, whereas we don't have trade secrets in the government context. And so we've all of a sudden moved the locus of activity to a place where the legal regime is different in ways that might be even more problematic. So, that's a long way of saying, ban bad use is not bad technology. But because there is no such thing as bad technology, maybe we could find the outer boundaries. A lot of professors love to do that. But it doesn't actually really solve the underlying problem, which is the government's going to be able to get it in all circumstances, and we can't trust that they're going to use it to actually advance the mission of their constituents. There might be circumstances we should delay the technology or defer the technology till we really understand it. What Colleen had said is that this is a chance for us to gather data about what works and what doesn't. And I couldn't embrace that more. I love that. The reality is that's not the way so many of our government processes work, that it's not evidence-based decision-making. So if we don't actually have confidence that we're going to get information that will feed back into smarter decisions at the end of the process, then we might, by deferring it, we're actually buying us time, but we're not actually likely to make better decisions. And I don't really know how to resolve that either.
Do you have thoughts on the allegations or evidence regarding racial bias in certain facial recognition technologies, and how are we going to get around that issue and resolve it in a way that people have restored confidence in these technologies? Because I think there's a widespread sentiment that these technologies do have deep flaws right now.
Yeah, they certainly aren't accurate at the same level for the same people, and especially women of color, I think in particular, the accuracy rate is extremely low. So I think you've probably all seen various headlines on members of Congress being misidentified. But I think we can go back to what Rebecca and Eric were talking about a little earlier and think about, does that mean facial recognition shouldn't be used at all? Or could it only be used for exoneration or sort of these more uses that are, taking away liability rather than giving it? I think there are, the question is the algorithm will give a prediction, and then the question is, what do you do with that? And if it, it feels like we're making too many type 2 errors, we're falsely identifying people who aren't guilty versus we, are identifying people who, falsely identifying people who aren't guilty versus finding people that aren't. I think you can try to think about, the technology we want to, on the first instance, we want to be extremely careful with it. And if we want to, bias it in one direction or other, we will only use it for that purpose, and then we will continue to improve it over time. I think the issue, again, with cities banning it is that in the private sector, it is proving to be a very useful tool. So the private sector will continue to improve the technology. And we actually had a DA from Santa Clara come and speak. I teach AI, and he talked about how he's seen other technologies develop over time. And first when they come out, they're not very good, and there's a lot of upset about that. But over time, if they're useful technologies, they continue to get better. And they get better and better, and then there is some sort of emergency or some sort of national event, which then swings the pendulum towards wanting to be more punitive and wanting to use stronger prosecution tools, and then these tools become legitimated. And so he, was saying it's important to try to have these conversations now before there is that sort of emergency event. And he talked specifically about, different laws that were enacted in response to a public, public murder or something that caused a lot of outrage. And that a lot of times technology will kind of slip through in those contexts. So I think, again, not banning it, but using it in a stepwise fashion is something that I would advocate.
Rebecca?
So just to flag an exciting development that's in the works, the National Academy of Sciences and the GIO office have had this meeting. I was really hoping Dean Mnookin actually could be there because she is one of the leaders in trying to develop standards and reliability for forensic evidence, of course. And so this meeting is about developing standards for algorithms used to match suspects to evidence, either in investigations or for evidence in court. And on face recognition, one of the standards that issues that is being floated around there is the question of standards for the input probe. So that might be one way to try to solve the problem.
Right. And we have about 10 minutes or so.
Alex,
Sorry, Eric.
I just did want to chime in on just a couple things. Again, the question with facial recognition, like everything else, is compared to what? And we have, just tons of historical examples of misidentification in the criminal system that was race-based and not justifiable in any other way. So this is a society-wide problem, but it is a problem, and we can't really embrace something like facial recognition technology as a society until so long as we know it's got these deep systemic biases that need to be fixed. My struggle is, so do we really want perfect facial recognition technology? Like, what's the win here at the end of the day? Because it will be weaponized by the government against us. We've already seen that in China, and we know what's coming for the rest of the world. So I'm not quite sure what to do about that. That's something that plagues me deeply because I don't know where the win is at the end of the day.
I want to really thank the panelists, Rebecca and Eric and Colleen. It's clear to me, and I think many of us in this room, that we really do need to engage in more scholarship along all of these lines. As Eric said, definitions are important, and it would be good, I think, in any law review article or editorial saying, this is what we mean when we're talking about algorithms or machine learning or predictive analytics. This is what we are talking about, just as a fundamental frame that is so important for helping educate the public and keeping the discussion on track. And I also think that, the panel has raised that we really do need to re-examine the way we are deploying these technologies and to create maybe some transparency around them. How do they work? Who is involved in writing them? what do we really want them to be used in certain circumstances? I think those are really good fundamental issues. I'm really happy that the Institute put together this panel to kick off the day, and I hope we can continue these discussions out in the courtyard and throughout the rest of the day. Do you authorize people to contact you via public internet access? Since you are all publicly available, I checked on your websites, because I think that you really are engaged in such interesting work, and the people here probably want to continue that conversation.
Sure.
That'd be great. Thank
Great.
you so much.
Thank you very much.
Thank you.
Okay, we're going to turn the photo.